Hi, I'm Peter Afrasiabi. The program you're about to watch, Winning on Appeal, Briefing Strategy, was recorded a few years ago, but I've confirmed the content is still current and timely and reflects the current state of the law. I hope you enjoy it. Hello, have you ever lost your case in the trial court, felt aggrieved at what the trial court did to you, and now you need to go on appeal? Or perhaps you've won, you're thrilled before the trial court, but now the other side is appealing and gearing up with their appellate lawyers, and now you need to defend your judgment on appeal. Well, this program's for you. This program is called Winning on Appeal, and we're going to address today the nuts and bolts and do's and don'ts of appellate brief writing and the strategy and the strategic issues that you need to think about when you're on appeal. My name is Peter Afrasiabi. I'm a partner at the law firm of One LLP, an intellectual property boutique in Southern California, the chair of the firm's appellate practice group. I'm also the co-director of the University of California at Irvine's School of Law's Appellate Litigation Clinic. Now, the views expressed here, of course, are not the views of the University of California or the views of One LLP. They're my views based on my experience as a litigator in the appellate courts. The place to start, as you see on this first slide, is what are the appellate courts? How do they differ to the trial courts? The central issue that often creates problems for lawyers when they go on appeal is they think that because they're in a courtroom with judges and a flag sitting behind the judge, that the nature of the discourse and discussion is the same as the typical discourse and discussion that we have in our trial courts day in, day out, that's common and familiar to us. The reality is very, very different though. Appellate courts serve a very different purpose to the trial courts. There's, as the slide says, a different center of gravity to these courts. And what that means is that trial courts are the courts that find facts. They make facts, they decide facts. They are deciding, does plaintiff win, does defendant win, was the light red, was the light green when the car went through it, and such factual questions. They're not charged with making law for an entire jurisdiction, either a state, part of a state, or in the case of the federal courts of appeal, many states. That role belongs to the Court of Appeals. This distribution of power between fact and law is a massively important one that frames the nature of how will you address your brief and the strategy in your brief. You also have another dynamic at play that you don't have in your trial court cases. When you're on appeal, you have 3 judges deciding a case, and so you get group decision dynamics at play, whereas in the trial court, you have 1 judge, of course. The other issue that's significant here is that there is systemic deference from the appellate court to the trial court. There's a presumption of correctness. This deference is unique, and it is something that you don't experience when you're in the trial court. When you're a plaintiff or a defendant in the trial court, there's no presumption one way or the other that you should win or lose. It's an open field. Anyone can win, anyone can lose, depending upon the facts and the law. Once you get on appeal, the systemic headwinds shift. There's a presumption of correctness, and depending upon the nature of the decision that you're appealing, as we'll discuss soon, there's even deference given to those decisions without reviewing them anew. So, all of this means there are strategic differences between appellate and trial courts that now we're going to talk about. The next slide is about credibility. Your credibility is critical when you go on appeal. This is a quote from U.S. Supreme Court Justice Robert Jackson. It says, "Legal contentions, like the currency, depreciate through overissue. The mind of an appellate judge is habitually receptive to the suggestion that a lower court committed an error, but receptiveness declines as the number of assigned errors increases. Multiplicity hints at a lack of confidence. Multiplying assignments of error will dilute and weaken a good case and will not save a bad one." This is a critical cardinal principle. It's the first key practice pointer that you truly interpret, absorb, and apply. Think about the distinction. In the trial court, you may plead 9 causes of action: breach of contract, a common claim, breach of fiduciary duty, fraud, promissory estoppel, blah, 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 blah. Because you want one claim to stick, survive, and get to the jury. And so you have multiple different claims and assignments that you're making in terms of your theories. And that's perfectly fine in front of the trial court where you want to get before a jury on a claim. Although, of course, there are limits. Maybe if you're throwing in a RICO claim, you've gone too far already. But that said, when you come on appeal, you're now in the appellate court. And for all practical purposes, this is the last court that's ever going to hear your case. chances of getting to the U.S. Supreme Court after your Court of Appeal argument are barely better than you getting hit by lightning right now watching this video. So that doesn't mean that you need to throw out everything again. In fact, it's the complete opposite. Now, why is this the logic that you need to carefully pick a couple of claims or theories or assignments of error and pursue only those and shed everything else? When you're in this last court of resort, surely we should bring everything again, right? The answer actually is no. You must shed that which is not material and relevant and focus in on one or two key points. Why is this? This goes back to the beginning discussion about the roles of the courts. The Court of Appeals presumes systemically that the trial court did things basically correct. You have the practical problem also that if you go on appeal and you contend that the trial court messed up when he dismissed your motion to dismiss, messed up in not giving you discovery on a certain range of topics, messed up in denying some summary judgment rulings, messed up in admitting evidence at trial, messed up on the jury instructions, what you are telling the Court of Appeals ultimately is that the trial court could not do anything right. That systemically is not believable. And so you are fighting headwinds that are impossible to fight against. For that reason, you have to narrow your set of issues down, and this is the first critical strategic decision you make. It's, as Justice Jackson said, don't over-assign error, because the receptiveness of the Court of Appeals to the presumption or the belief that the trial court could have made an error is going to go down drastically when you're saying that judge couldn't do anything right. And of course, at a very practical level, the appellate judges know the trial court judges. They know they're hardworking public servants. There's a 90% affirmance rate, at least in the Ninth Circuit, and that's pretty consistent across the circuits. And so they know that by and large things are done correctly. If you're saying they can't do anything correctly, you've already lost your audience. So let's go to the next slide and talk about you're ready to go on appeal. When do you go on appeal? You don't like what's happening in the trial court? It seems pretty easy, right? You get an adverse decision, you go on appeal. Well, that's not how it works. You need finality. Finality means that the case has come, for all practical purposes, to a complete conclusion. There's nothing left to litigate in the district court. This concept of finality traces all the way back to the Judiciary Act of 1789, and it's been a cornerstone of the appellate system since then. You must have a final order in order to get to the Court of Appeals, and the reason for this is the same sort of policy we were talking about in the beginning, and that is the distributed roles of power between the courts as to who does what and when they do it, and also deference to the trial court. The trial court has the case. There's the belief that they should be able to run along and deal with their case and all the decisions day to day, and the Court of Appeals will look at it once and only once at finality. So you need to reach the end of the case. There are some exceptions we'll talk about in a minute, and that is when you have a final order or judgment that's been entered. And under the Federal Rules of Appellate Procedure, you have, depending upon who the parties are, 30 or 60 days to file that notice of appeal. That is a jurisdictional deadline. You can't file it on the 31st day and come in and say you made a mistake, attorney neglect, and get away with it. You will have lost your client's appeal. So, file. Now, one of the issues that exists here is what happens if you have a premature notice of appeal? The federal rules, fortunately, have a scenario that is designed to stop you from being caught in a trap. The trap being you think you have a final order, you received it, you file a notice of appeal, but technically it wasn't final because there still needed to be, for example, maybe a judgment entered, and your appeal predates the judgment is entered, you don't file a new notice of appeal, the judgment just tracks the order. Your notice of appeal should ripen forward under this Federal Rule 4A2. Now, unfortunately, as with many rules, the ripening procedure has been whittled away a bit. And so cautious lawyers filing notices of appeal early have actually sometimes been the victims of gamesmanship where they have lost their appeal when a subsequent order is entered and they don't file a new notice of appeal. So let's look at this because this is the first important minefield that you're wading into that's unfamiliar. So if we look at the next slide, we see Rule 4A2, and that's what it says. The history here was really designed to codify the pragmatic or cumulative finality doctrine that existed and simply avoid substance over form to protect you. Well, what happened? The Supreme Court struck back. They got a case in 1991, and here are the facts. There was a bench ruling granting summary judgment, the notice of appeal was filed, and then the judgment was entered. The court held the notice of appeal, even though technically premature because it predated the judgment was the final appealable order, the court said nonetheless, the notice of appeal will ripen under the premature ripening provisions of 4A2, simply because it wouldn't be reasonable to hold otherwise and because all that remained was a ministerial act. So far, so good. What's happened, unfortunately, as you see on the next slide, is a series of cases where people have filed prematurely. You think what's remaining is sort of ministerial. Turns out it's not. And so this question of reasonableness and what's ministerial has spawned catastrophes for litigants in the courts of appeal. First case we see here, Kennedy versus Applause. This is coming out of the Ninth Circuit. You had an order granting fees and costs. Party filed a notice of appeal. Then there was a little more briefing, and the court issued an order specifying the amount of fees and costs that were owing. No new notice of appeal was filed. Party moved to dismiss the appeal, and the Ninth Circuit said, yes, there is no appeal before us because the original notice of appeal challenging the order granting fees to the prevailing party on the issue of prevailing party wasn't simply an order that had all that remained to be something ministerial. Instead, there was a sort of a set amount of substantive issues that needed to be litigated and addressed. Specifically, what were your hours? What was the lodestar? How much time? Was it reasonable? What's the correct amount? And so the party lost their appeal. And note here, the party lost even the underlying issue that they'd filed the notice of appeal on simply because that was not an appealable order and it wasn't timely. They were completely out of luck. That is not a call you ever want to make to your carrier, so you must be careful. Here's another example also coming out of the Ninth Circuit, and this is one coming in the context of summary judgment. The Jack Raley construction case. You have an order granting summary judgment, notice of appeal is filed. There's a proposed order lodged that had interest. The other party filed objections to the proposed order. You had a little bit of briefing over the propriety of the interest and the amount, and then a final order was entered addressing the interest issue. No new notice of appeal was filed. The court held that the first order did not require a simple entry of an order, i.e. something that was ministerial. And so the appellant improperly confused the first with the final order. As such, the appeal was dismissed. The party lost the challenge to the summary judgment ruling, not just the interest calculation. You see the rationale from the court there in the quote, but this, for a party, runs against the grain of what you would think in terms of having been overly cautious in filing a notice of appeal. So, if we go to the next slide, what's the lesson here as you wade into this appellate world with your case? The ripening lesson? This pragmatic approach should protect you. It doesn't always. So, my advice, if you're in doubt as to whether your notice of appeal is premature because there's a subsequent order that may or may not be ministerial, file a new order of appeal against the second order. It's a $425 filing fee, and it's better to pay twice your filing fee and be sure that you've appealed rather than take the risk and let someone exploit this issue against you on the other side. The next slide is just some tolling issues, and these come up and they're complicated, and it's the time when you need to be very, very careful. You may have been through trial or a judgment's been entered, and you get post-trial motions often. There is tolling for some of them in terms of the notice of appeal, but those motions, of course, have to be filed within a certain amount of time under the federal rules, and you see here with Rule 50B judgment as a matter of law motions. If a Rule 60B motion is filed, and that's fraud, mistake, new evidence, there is no tolling on the time to file a notice of appeal. So you still have to file your notice of appeal from the judgment, litigate your Rule 60 motion, and then file a new notice of appeal from that. So when we go to the next slide, what we're now looking at is this compromise that has developed over the last couple of hundred years on the doctrine of finality. As with all rules, as I said in the beginning, there are exceptions, and this is the compromise. Here are some scenarios where even though you don't have a final order, you can get up to the Court of Appeals and get an audience. So the first one let's look at is Rule 54B certification. This is the scenario where you have non-final orders that have been entered, but you can go to the trial court and say, hey, look, let me get up on appeal on this. Please certify it because there's no good reason for delay, and it's a significant issue. Maybe it's resolving one of the theories of relief against one of the parties, and that party needs to get up, or a scenario like that. You can go to the district court, seek certification. If the district court certifies and says, yes, I think it's okay to partition this issue out, send it up to the Court of Appeals right now, you can then go to the Court of Appeals and ask them to accept it. The other scenario is the collateral order doctrine. This stems from the U.S. Supreme Court case Cohen cited here, and effectively it deals with situations where there's been a trial court ruling below, you're not final, you can't get on appeal, but if you don't get on appeal right now, the issue that's been adjudicated against you may effectively be unreviewable. And so the classic example to think about is, you move to dismiss on the basis of qualified immunity. For example, I don't know, maybe you're a prosecutor or a judge, and you prosecute someone or you put someone in jail as a judge, and the person's aggrieved and they file a lawsuit against you saying, you broke the law when you put me in jail. Well, you, the judge, would want to move to dismiss and say, hey, I have immunity. You don't get to sue me for acts I do in my official capacity as a judge, and so I'm not able to be a part of this lawsuit even. It should be dismissed on immunity grounds. If the trial court refused to dismiss it, that's a scenario where the judge would be able to go on appeal and say, or the prosecutor, and say, hey, you, Court of Appeals, need to take this under the collateral order doctrine, adjudicate it instantly, because if you don't, I get dragged through trial court litigation, I have to wait till the end of the case, and then I get to appeal to say I should have had immunity and never have even been put here in the first place. That's the classic example. The other scenario is sort of maybe scenarios where the attorney-client privilege is breached, and you're ordered to produce a whole host of documents that may be privileged. Once they're produced, the bell has been rung. You can't wait till the end of the case to unring that bell, and so you need immediate help. The third scenario is a statutory basis where you have non-final, but by code they've been deemed appealable orders. And so the examples here under 28 U.S.C. 1292 are preliminary injunction motions, the appointments of receivers. If those types of orders are entered, you can appeal them immediately, and you have a parallel track running in the Court of Appeals as you continue with your trial court litigation. 1292B of Title 28 lets you seek certification on very important questions of law where there could be a difference of opinion, and where if it was taken instantly, it may help terminate the litigation. And so a classic scenario here is if there's a standing challenge and the court says, well, no, I think you have standing to maintain the lawsuit, but there could be close legal questions on standing, that may be the type of thing that can be taken up immediately. And finally, we have mandamus review. And this is review that's predicated on the All Writs Act, and it allows review in certain circumstances if it's a critical question, there's really clear error that happened, and it's generally for scenarios where court rulings are heavily interfering with separation of powers issues. So those are some compromises on finality where you don't have to wait for that final order. So as we turn now, one of the first issues we need to talk about as you're working through your appeal is what's the standard of review? What are standards of review? Well, standards of review, as you see here, are the prism through which appellate courts look at lower court decisions. And there's a spectrum of deference given by the appellate court to the lower court depending upon the decisions that have been rendered by the trial court. Now, this is the second stop along our way of something that's genuinely unique in this realm you're now in this appellate realm, that you don't experience in the trial court. In the trial court, when you file a lawsuit, there's no deference to anyone about anything. The question is, what's the law, what's the facts, and how does it come out? The trial court makes a determination, and that's it. There's no deference given at any stage in those proceedings. When you get on appeal, though, there's suddenly an amount of deference that is going to be given to that decision of the trial court on a question the trial court considered. This, of course, means that even if you may have been ultimately right on a conclusion, deference may still require that you lose. So, first standard of review where that could happen is clear error. This means for a certain range of trial court decisions, the Court of Appeals will reverse only if they have a definite and firm conviction that there was error. So this concept of deference here is critical. It's based on the distribution of powers within the judicial branch and the need to not constantly undo everything that was done, and the idea that for certain types of issues and decisions, the trial court in the first instance is the best able to make it, and the Court of Appeals shouldn't be second-guessing what the trial court did. So, for example, the credibility of a witness. The trial court is sitting there, it's watching the witness testify, and it's able to figure out, is the person shifty, or are they telling the truth, the totality. There are things that sometimes don't appear on the cold, sterile, black and white transcript of the record. If a trial court finds someone to have lacked credibility, the Court of Appeals generally will not reverse that unless it feels firmly in the camp that the trial court erred. Now, what this could mean is the Court of Appeals could look at it and say, yikes, I don't know, if I'd been a judge in the first instance, I probably wouldn't have found him credible. It's close, who knows? But I don't feel firmly convinced this trial court was wrong. Therefore, I still affirm, even though I may harbor some real feelings that there was a mistake. That's the first concept of deference that's given to trial court decisions, and it's a major roadblock that you have to get over if the nature of the decision you're appealing falls into clear error review. Now, the next issue is questions of law, which are reviewed de novo. Here, there's no deference. This goes back to the idea, of course, that courts of appeal make law for an entire jurisdiction, so when it comes to what the law is, they're not going to give any deference to the trial court. Practice pointer, you want to frame your issues on appeal as legal questions because there you have no deference being given. Then we have abuse of discretion, which is deferential also, and the Court of Appeals basically must be convinced the lower court made a mistake. And this is generally given for things like evidence determinations, how long you get for trial, how many hours per witness. Those are the types of decisions that are well within the province of the trial court, and the Court of Appeals doesn't want to get involved in those day-to-day activities where the trial court's better at doing them and has more experience. And so unless they have this sort of convinced belief that there was an error, they're not going to reverse. Finally, we have arbitrary and capricious. This is generally the standard used for administrative rulings when you're challenging the act of an administrative organization from the executive, built upon separation of powers again. And again here we have deference to the co-equal branch of government. So we're not just simply going to review the acts of the co-equal branch on an area within their expertise, for example, immigration, and do what we want. We give a level of deference, and so if it's effectively, the standard is if the actions were rational and reasonable, we affirm, and we reverse if they appear to have exceeded those bounds and become arbitrary or capricious. So these standard of reviews are critical to assess, understand, and apply properly so that you don't lose the appellate audience that you're trying to convince of the righteousness of your case. So let's, on this next slide, look at briefing. And these are some issues that you now confront as you start getting into your briefing, dealing with the standard of review and the idea of prejudicial error. First point, you must always, in the beginning of the brief, in the beginning of the argument section, depending upon which court you're in, you must state the standard of review. Now, what you also have to do is understand what that means. All too often, parties tend to cite a standard of review and simply say it's, clear error, and then they proceed to argue a case as if they're just simply pointing out an error. That's a mistake, and if you do that, you will telegraph to the appellate judge, who is very fluent in standards of review and is looking to figure out what prism they should be looking at the lower court decision through. You will lose them, and they will realize that you're not aware of what you're doing and how you're managing this appellate process. So, practical advice here. First one, relate the standard of review to the argument. Don't simply say it's abuse of discretion and then point out how the trial court erred. You need to note that it's abuse of discretion review, and you need to argue and explain why what happened below was unreasonable and significantly wrong, as opposed to just having been an error or a judgment call that could have gone either way. Related to this is a very, very critical principle that we talked about in the beginning of this presentation, but that's relevant still, and that is that there is a basic presumption of correctness that attaches to the decision below. And what this means then is that it's not just enough to point out that there was an error somewhere. The error needs to have actually been prejudicial. Errors occur all the time, but if they don't have any substantial or potential impact on the case, the fact that you can show the Court of Appeals that a piece of evidence was admitted that was irrelevant and shouldn't have been admitted isn't going to be enough to win. You need to get over this concept of prejudice. So, the advice here again is you must understand this because you're dealing with a court that systemically is predisposed to affirm the lower court's decision. So, if you're on the appellant side, argue it and understand it. And if you're the appellee, do not forget this at all and exploit it. All too often, what you see in briefing is an appellant tees up an issue of, for example, erroneously admitted evidence, and the appellee runs along and fights on that battleground back and forth about why the evidence was properly admitted. And the appellee is missing the bigger picture when they fail to point out that the alternative is that even if it was admitted improperly, who cares? There's no prejudice here and it doesn't affect the outcome. Now, the related advice here for appellees in particular is that the Court of Appeals can affirm on any basis in the record. This is a massive leg to the stool of appellate advocacy for the appellee. And appellees often forget this, sort of related to that example we just ran through, is that you may be fighting with someone over whether the copyright claim should have been dismissed or not, but there may be an alternative basis to affirm that the appellant hasn't litigated and teed up in their brief, but it doesn't mean that you can't exploit it and point it out to say that there's another way to affirm such that the court doesn't even need to reach that issue, or it doesn't matter what the outcome of that issue was. So, presumption of correctness, alternative basis to affirm, and the need to show prejudice. These are the next component after our standard of review that are critical for you in briefing your appeal. Now, let's start getting into some nuts and bolts of your brief. This next slide talks about using an introduction section. The goal here ultimately, and we'll work through these 4 points, but the goal ultimately is to distill your entire argument. What happened below? If you're the appellant, the error below. You need to distill this down to 1 page, for example, so that you're forced to get to your core issue, what the core error was, what the core flaw was in the district court's reasoning. A corollary to this is this will help you immensely preparing for oral argument. All too often what happens is you fill out your brief, you write the standard of review, you write the facts, you get to your argument section and you say the district court cited this case, it was wrong, the other side said this, they were wrong, and you have not distilled what happened into a workable framework. Using an introduction forces you to do that. So you get to succinctly describe why the court erred, and that becomes the frame of your argument. This is fantastically useful for the reader, the judge deciding your case, to have some sort of frame of reference. Remember, your appellate judge isn't sitting around aware of your case and everything that stands in the background of your case the way you are. The appellate judges are picking up this case. They may have 20, 30 cases on calendar, and this is just the next case that they're going to look at. And as they read your brief, your introduction section gives them a framework, sort of a parachute zone, so to speak, of where they're jumping into. And they have an understanding then of what's the issue, what happened, what's going on, so that when they plod through the standard of review, the statement of issues, the statement of jurisdiction, the procedural and factual background, they can contextualize it as to where this stands in relation to what this case is ultimately about. And as they can read those sections, they can have an understanding of the facts that you're identifying, how and why they even matter, because you framed it for them in introduction. This is allowing you, in essence, to plant your theme, which then gets woven throughout the brief, and you've effectively set the stage properly for the meat of the brief, which is your argument section. So my strong advice is to always use an introduction section. Try to keep it to a page, half a page if possible. Sometimes they may run over, no doubt, depending upon the complexity of the appeal. But generally, you should be able to state why the lower court erred in half a page to a page. If you're incapable of doing it, it's probably a sign that you haven't distilled what happened below enough, and so you should keep working on it. The next issue on the next slide when we're in briefing is choosing your issues. You must choose them, but you have to choose them wisely. You're required to outline what the issues are on appeal, and of course, when you get to the argument section, you're going to be litigating those issues. But this goes back to the credibility call we talked about in the beginning. You must, on the front end, strategically and cautiously decide which arguments are likely to win and which are not. You are going to have to shed something in order to maintain your credibility and get to the heart of where the error was and have the Court of Appeals' attention. This is the time to do it. So don't simply throw out arguments without explaining them or exploring them. If you're going to make an argument, make it. If you're not going to make an argument because it's something that you've decided isn't good enough to show error, then drop it. Don't just drop things in footnotes and hope for the best. This gets to the issue of footnotes. The next slide, as you see, is footnotes. Strive to avoid them. My experience, having talked to appellate judges and the experience of other appellate lawyers who do the same on a regular basis, is that footnotes are an example, frankly, of poor advocacy. They're off-putting, they're not helpful to the reader, they interrupt the flow of the argument, and they interrupt the readability of the argument in your brief. If something matters, you should say it in your text. And if it doesn't matter, then you don't need to say it. Footnotes aren't going to save you. So, footnotes in general are the types of things that belong obviously in scholarship. So if someone's a law professor writing a long law review article or a dissertation for a PhD or a complex science paper, of course footnotes are there. But legal briefs and judicial opinions, for that matter, are not really works of scholarship. And that's not what they're supposed to be, which is why, of course, if you're familiar with Judge Posner's opinions that he writes, he effectively never puts footnotes in his opinions because he doesn't believe they're appropriate. The quote we have here is from Justice Jim Humes, the presiding justice of the First Division of the California Court of Appeal, the First Appellate District, and he was also a former legal teaching writer. His quote is, "If you want to make sure someone doesn't read what you're writing, put it in a footnote or a block quote. The human eye passes right over footnotes and block quotes." This is another cardinal principle then, as well as the footnotes, the corollary is the block quotes. And here's another tidbit of advice for legal writing in your appellate brief. If you write, "The Copyright Act provides in pertinent part, colon," and then you have a block quote of copyright text, the human eye is going to pass right over it, go to the next paragraph. If there's something important in that block text you want the reader to read and internalize, there's a different way to lead into that. If you feel you must quote the statute in that way, you could start, rather than saying "the Copyright Act provides in pertinent part," instead what you say is, "The Copyright Act demands that plaintiffs register their work timely if they want statutory damages, quote, colon," and then have your quote. What you've now effectively done is made an assertion and you've forced the reader to see if the block quote backs up your claim. That can force the human eye, rather than skipping over a block quote that's single-spaced and double-indented and whatnot, to actually read it. So that's another briefing tidbit of advice with footnotes. Next slide. What exactly do you want the court to hold? This is something you need to think about carefully, long and hard as you work through what the error was. And it's going to be important when you get to oral argument also. But what do you want the court to hold? Remember, your audience here isn't deciding just whether you win or lose. The audience is thinking about the effect of this decision on millions of other people across a whole jurisdiction. The appellate judges are going to have to write an opinion that says, "We hold that," and then there's going to be some text that comes after that. That text is going to be important in terms of the ripples that flow from the holding for other potential cases. You need to think about that, and you need to tee this up for the appellate court. So what often happens in briefs, you see, is that the proposed holding really isn't given. There's a whole bunch of discussion about this case and that case, and there was an error, there wasn't an error, and the court got the facts right or wrong. But no one peels the onion back enough to get to the point of saying, what should this court hold? You may get the question at oral argument. You want to be ready to answer it. The best way to be prepared to answer it is to give it thought and write in the brief. And so my general advice is that somewhere in your argument section, after you've battled about the cases and the facts, you should somewhere have a paragraph that says, accordingly, this court should hold that. And the language you put there should be the appropriate holding for your case based on the operative rules of law and the facts of your case, with some thought given to the ripples that flow from that holding. This is a great way in advance to prepare for oral argument, and it's a great way to make sure that you have distilled the cases and your facts down to their essence. Now, another key component here is that you want to think about narrow holdings. Courts of appeal are concerned about broad holdings. The broader the holding, the further out on a limb one goes, the more unintended consequences can flow from a court's decision. So if you can find a narrow holding that has the least amount of ripples that sort of flow out from that, that is what you want to look for and think about. So when you're drafting that argument section, keep that in mind. A common example is that if you can get a holding that's based on statutory text or interpretation and prevail that's narrow, That's the best way to go, as opposed to telling the court that it should void a statute on due process grounds, which is a very broad holding with immense and unpredictable consequences to decisions that hold statutes unconstitutional on due process grounds, obviously. The next slide is exact disposition. You need to be thinking in your brief, as you're working through your appeal, what exactly you want the Court of Appeals to do with the case. The most common thing that you see in appellate briefs is that people say, for the foregoing reasons, the court should reverse, period. And the conclusion is really an afterthought. That, it's just a pro forma thing you toss in and then you sign the brief and send it off to get printed, bound, and filed and whatnot. This is a mistake. You need to think about what exactly you want the court to do. If you're an appellant, telling the court you want the court just simply to reverse isn't enough. The Court of Appeals is thinking about its relationship with the trial court, and it's thinking about, okay, if we reverse, what is the trial court going to do on remand? What exactly is the trial court going to do? Is it going to open up the whole case again? Is it going to open up a limited portion of the case? Is it going to take more evidence, not take more evidence? Can it revisit certain things? Are there certain things it cannot revisit? What are the specific directions given on remand? All too often, you hear in discussions between appellate lawyers, appellate judges, and the trial court judges, frustration at the district court level when a case just gets reversed and sent back without clear direction. And so there is a need among all the constituents in the system to give clarity to what should happen on remand. You need to do this in your brief. And so give some thought to that so that you're very, very clear about what you're demanding on remand if you're the appellant. So, we're in our briefing. The next slide is your audience. Your case, of course, is critical to you. This is your appeal. It's your baby. You've lived with it forever. But remember, the appellate judges, this is just one of many, many cases on the docket. And if, like me, you're a civil litigator who's going up to the Court of Appeals, maybe in the Federal Circuit on patent cases or in the Ninth or Second Circuit on my copyright trademark cases, my case in intellectual property matters to me a lot. I love it. I live it. I breathe it. But the judge has many, many other cases, and many of the cases may be death penalty, criminal cases where people have been sent to prison for a long time. Those cases weigh on a judge's mind heavily, obviously. And so your case is one of many that is being adjudicated and thought about. So what you need to do is remember that, be aware of that. And this requires being concise and transparent in your arguments. Don't simply count on the fact that the judge is very, very smart and the law clerks are very, very smart and they're out running around solving your problems for you, looking for ways to help you. You need clarity in your briefs. This ties back a little bit to the footnote discussion, and that is often in the trial court you may dangle some issues in briefs and not really close them out, and they just get placed there as placeholders to avoid waiver and just to maybe trigger something in the judge's mind, you think, and there's no great downside to doing it, you feel. Maybe you even do it to preserve the issue for appeal later. Now is the later, so you must decide to address something or not address it, and then if you do decide to address it concisely, and if you're passing on it, don't exhume it in a footnote. The next slide. Who is this panel of these judges that are going to decide your case? How are they chosen? This again is a way that's different to your trial court experience in the district court. Once you're in your district court case, once the case has been filed, you're assigned your judge. You know your judge. You may appear before the judge often. You have other cases. Your partners appear before the judge. You get some intel on the judge. And then you start developing a rapport and getting some experience with the judge, and you have a sense of how the judge manages and handles issues. That then becomes a living, breathing organism in your trial court litigation about how you brief issues because you have experience with the judge. This is very, very different. You are setting up a target not knowing your audience other than knowing they're appellate judges and there are these systemic headwinds that we've talked about that you need to be aware of and write to in your brief. But you don't know who they are when you write. You don't know their jurisprudence. You don't know if you're going to get people on the extreme left, the extreme right, in the middle, people who you may have a civil case, but they were all criminal prosecutors by background. You just don't know. What you know is that you're going to get 3 randomly appointed. You know that they're going to start getting your case, at least in the Ninth Circuit, 8-12 weeks before oral argument so that they can start working it up. And sometimes it's maybe as little as 6 weeks. So on the front end, there's 2 pieces of advice. One is that write your brief to the common denominator that could cut through any kind of political persuasion. And so the advice I often give when we're litigating our cases with my students in my clinic and we're going up to the court is find where there are procedural errors that led to an unfair proceeding or an unfair result in some way, because process-based errors seem to be the types of errors that have the largest common denominator applying to judges that may hail from the left, the right, or the middle. If you're framing it only in substantive terms about the outrage that befell your client because of the decision on the copyright case, for example, you may force yourself to brief into an audience that is only an audience, maybe it's on the right or the left, that would find your case appealing, and you're excluding half of a potential audience for your appeal. So that's a good tip to keep in mind, this procedural prism, as opposed to only focusing on the substantive prism, which may limit the type of audience that would be receptive to your argument. The other piece of advice here on the slide is that when the case calendar comes out, don't just look at your case and say, oh great, I'm up on this day at this time. Spend some time and look at the other cases that are set for oral argument that day. In the Ninth Circuit, what you'll often find is that cases get bundled together by the staff attorneys and the clerks who are working up the cases for the court, and they will often bundle them, in a very loose way by issue. So, for example, I've found when I have my copyright appeals going up to the Ninth Circuit, those are infrequent appeals. And so often there may be 2 or 3 copyright cases bundled together that day. And so the same is true in other substantive areas, you'll note when you look at the calendar. This is really useful to look at and see. And if you find that you've been bundled with other subject matter similar cases, reach out to those lawyers, find out what their appeal's about, look at their briefs. Sometimes you have cases raising near identical issues, near similar issues. And so you will get some very good insight into looking at that other set of briefing, what both parties have said in that other case, and it'll trigger some issues in your case that you may need to confront. And it'll also alert you to the fact that the court's looking at your case and concerned about your case, but it has to fit this other case into the puzzle of the law that it will be issuing for the entire jurisdiction, and that may well affect how you approach oral argument. So let's get to a case study now. And this is an appeal in the Ninth Circuit called Gutierrez versus United States. There's the Ninth Circuit case number. This is an appeal that our firm was brought in to take on appeal and defend a lower court judgment. So what was this case about? This was a judgment received by some well-known PI lawyers here in Orange County, California, who received the largest federal Tort Claim Act judgment in history against the U.S. government. They received a $54 million verdict for their client. The facts were tragic and heartbreaking. You had the factual scenario of a 4-year-old girl who was in a car that was T-boned by a U.S. government employee. The 4-year-old was left a high-functioning quadriplegic at age 4 on a ventilator dependent. The most horrendous fact pattern you can imagine. So the case gets tried to the bench, because FTCA cases are tried to the bench. And the district court, after hearing all the different conflicting evidence about economic and non-economic damages, the district court issued an award of economic damages of $25 million and a damages award of non-economic damages of $31 million. The $31 million was based on $1 million a year for 31 years because the experts' consensus was the 4-year-old girl, the victim, wouldn't live for around more than another 31 years. So the government brought this up on appeal to the Ninth Circuit, and their fundamental issue the government raised is that too much money was awarded. And this was framed in complex legal arguments, law and economics type material, complex arguments built around what should be the ratio of economic to non-economic damages in this type of a case, and in personal injury type cases in general. And it was built around this complex economic analysis and triggering case law, where cases had sort of batted about the idea of whether one should have it. So after the government filed this brief and mounted this complex argument, the trial court lawyers asked my firm to come and defend the judgment on appeal. And so the first question that this raises for you when you're in the respondent situation is, what is the prism through which you're going to frame this appeal for the court? The government had done a very fine job of framing this issue as one of sterile money, economic analysis, case law, ratios, and the like, and had tried to sort of get the prism to be that prism. The return focus must be by a respondent to not accept the terrain that the government or the appellant has defined as the turf, so to speak, and make sure that you get some control over what you think the proper terrain is. And all too often, a response brief is simply a sort of tit for tat. They said this, they're wrong for this reason. They said this, they're wrong for that reason, instead of taking the opportunity to really reframe the issue. And so some of the tools that you can use in your toolbox, are as follows on this slide. Who was the trial judge? Here it turned out it was a highly respected chief judge of the Central District, who was a very, very well-known conservative judge, not remotely a sort of the type of judge who bends over backwards to be, hyper friendly to plaintiffs. Also, frame the issue through the standard of review. This, for a respondent, is always critical because now you're talking about factual findings being entitled to deference, which is a different type of analysis to that of a ratio analysis under the law. And then, of course, it's a case with great emotional appeal, but you have to be very careful not to overplay your hand. It can't be a jury argument to a court of appeal. You have to take the relevant facts that may have some emotional appeal, but funnel them through the appropriate legal policy, cognizant of the fact that this case has ripples and permutations for other future cases. So, in other words, we had to elevate these issues from the narrow terrain the government wanted to fight on to a different terrain. Took it up to a city view, so to speak. Well, as you see on the next slide, as we talked about before, an introduction is critical. And here, as an appellee, you can instantly frame the other side's case in new terms. And this is one thing that's very, very useful to do. This gets away from the tit for tat. You must study the other side's brief and distill what the essence of their argument is. And here, we did that. When you get past all the economic analysis, in this case, ultimately, the government was saying it was too much money. In other words, this girl who suffered that fate was the recipient of a windfall. When framed in those terms, you can suddenly reorient the analysis. And so that's what a good introduction should be able to do on the respondent side and on the appellant side to state your theory of the case. And so that is what we did here. And you see that the quote, the very first two lines did that, to reorient the court into what really matters from our perspective. As we turn, well, actually, before we actually turn to the next slide, one last point. In this very, very first paragraph, we were referencing, in essence, the standard of review and who the judge was. And that's very critical, too, because that helps the court remember this was not just some lone district court. This was a judge of a certain kind. So when we get to the next slide, you see paragraph 2 of the introduction. No abstracts here. This is the who and the what, and this is where you must refine and distill your appeal and get away from abstract discussions about what the grand rule of law is, for example, and get to the nitty-gritty of what's happening. And so what we needed to do was orient the court to the government's position says it's unfair. Well, let's look at what happened, and in a very simple paragraph, frame this for the court, because the court needs to understand this question in terms of fairness as opposed to ratios, and that's what this paragraph does. As you turn to the next one, you see paragraph 3 of the introduction. This is what the judge did below. And so we have framed this in terms of, as you read here, to compensate the plaintiff for this loss, chief judge, and there we're identifying the chief judge, awarded a certain amount, and then awarded another amount. And we tied those two amounts together, showing they're not that great and why they happened. This helps reorient the court away from the other side's frame of reference. As we move to the next slide, what we see in our introduction is that we have framed the issue and we've picked up on the standard of review. And this is critical. This is an appeal of a trial court decision. It's not just simply a de novo question. And so you want the Court of Appeals to be thinking about your case instantly through the correct prism by noting that there's clear error review here, which requires the court not to think that maybe the judge gave too much, but to think the judge unequivocally gave too much, and that's the only way they could possibly reverse. In other words, the judge went off the reservation. Much harder for a Court of Appeals to entertain that idea than it is the idea that perhaps there's a ratio imbalance. As we go to the next slide, this is your facts section in your brief, and this is just a graph that was taken from the trial court record that we put in the brief. Charts and graphs are very, very useful in briefs, and I believe this cuts through all litigation, trial court and Court of Appeals, but it's very useful in the Court of Appeals also if you have a graph or an exhibit that was used that's critical to the case, some key email, for example, rather than quote the email, cut and paste the PDF into your brief so they can actually see it in its real glory. This is just one. And so the facts are very important to sort of portray to the court in the appropriate way, and graphs can be useful, but also frame your facts through the standard of review at all times in the substantive legal prism. Every case has a massive number of facts that are really, really important at trial because you want to get everything out to cover every possible base. But once you get on appeal, the issue that's been taken up has narrowed that range of relevant facts because not everything's at issue again. And so you want to frame your facts through the issues and the standards of review so that you get the facts that matter and not irrelevant facts, because you need to avoid the sideshows for the court. The next slide we look at is entitled Argument, and you must destroy the other side's argument, but you must do it on your terms, not on their terms. And this is what I mean by talking about avoiding the sort of back and forth tit-for-tat type stuff. You need to find a schemology, some sort of structure and thematic framework that for your appeal works to contextualize the law and the facts. That gives you this operative narrative that you can then funnel your argument through and talk to the court. If you don't, and it's harder to do it, but that's why it takes time to work through figuring out and distilling your case to its essence. Because if you don't, what often happens is you simply fight on the other side's terrain and it just becomes a tit for tat, where you're responding to everything the other side has said in order the other side said it, and you haven't given the court a framework to sort of bite and adopt your worldview. And so, as we move on to the next slide, you see the important use of signposts. Signposts are very, very important in your appellate briefs because, again, you have courts that are getting very large briefs, a large volume of briefs, and the signposts are constantly framing the issues for a court that has no familiarity with your case at all. They're useful in the district court also, of course, but what you know when you're litigating in the district court is that by the time you get to your summary judgment motion or a trial brief, the judge you're talking to is very, very familiar with your case already, and so it's easier to shift the nature of your legal writing. You have to forget that when you go on appeal and remember that your audience doesn't know you, and so signposts are critical to illuminating the issues, the facts, and what's going on, and reorienting the issues for the court. Here we have an example where the signpost, very, very simple, it's not magical, but what it does is immediately contextualize for the court why these ratio cases the other side were giving are irrelevant. We've identified they're old and they're from a different jurisdiction and they don't apply. That lets the court very quickly understand, before it even gets into the tit for tat as to what was the scope of a holding or how broad the holding should be of that case, that there's a prism by which these cases don't even matter and you don't need to even assess them. And so structurally, you have given now something to the court that allows the court to demolish the other side's argument and get to the real issue, which is protecting your client. They also, as you see on this next slide, allow for succinct issue and argument framing. It's a great way of distilling what your argument is in those next paragraph or pages into one sentence, one line, one sentence, which will be very important for you when you get to oral argument. This is trickier here because in this case, for example, you're confronted with very complex law and economics material written by a highly respected judge from another circuit, and before taking that theory head on, you need to demolish the theory. We actually here did the inverse of what we talked about, the way we referred to our trial judge who held for us. We never referred to that judge by name. That's another small but subtle form of appellate advocacy that you can use, because had we constantly referred to the analysis of Judge X and Y from that circuit, you lend more and more credence and credibility to that analysis by buying into the name. It's the exact same reason we did it for our judge. The next slide we get to is your conclusion portion of your brief. Here, you need to maintain your theme, you need to tie out your theme, and you need to use tools that have powerful atmospheric value. And so here you can see we used a couple of tools from the lawyer's toolbox to close this out. Rather than simply say the court should reject the government and affirm, we reoriented again what the government was arguing, which is that a highly respected, well-known judge who's not hyper pro-plaintiff friendly, not saying that, of course, as you see, but saying the judge's name, constitutes a windfall. and of course concluding that it doesn't. And then noting that the government didn't even ultimately settle on a clear theory. When the other side doesn't settle on a clear theory, it gives you great ammunition to tell the court they don't even know exactly what you want them to hold. What are you going to hold? They can't even give it to you. That's a way of putting a wedge between their argument and the court. And then a bit of an atmospheric flourish, but the reference to the poor and the name of the plaintiff in quotes, tied right into a very, very well-known Supreme Court case dealing with horrendous tragedy that befell another child, the DeShaney case that you may know. And we were able to frame it picking up on government concessions below about their professed apologies for the damage for which no amount of money could ever compensate, and now here they are saying that it was too much money. So you can use some of these tools to contextualize this in a way that is effective advocacy, but it's not over-the-top emotional pleas that are constantly focusing on the underlying facts in a jury-type argument. Next slide. Don't oversell. This was a horrific accident. Child damaged profoundly. It can be too easy to overplay that hand. It can be too easy to overplay it at the trial court also, obviously. Remember again, the appellate court is making law for a jurisdiction. It's constantly thinking about the ripples that flow out. It's not making the facts. It sees a massive number of cases all the time, many of which are horrendous and heartbreaking and gut-wrenching. It is not going to buy into the hyper-emotional themes that may well work before trial courts, bench or jury, where the goal is to make facts. Now the goal is to make law, so you have to keep that in mind. The next slide is oral argument. And very, very briefly, I hope you watch the next presentation in this series on oral arguments, but very, very briefly, your oral argument is going to give you 10 or 15 minutes. You're going to get very aggressive questioning. When you're going to be only having 10 or 15 minutes to talk about your case, you're going to have to be prepared to talk about your case quickly in a distilled form. Thinking about that when you're writing your brief is critical. All too often, because there's a year gap between brief writing and oral argument, sometimes more than a year, sometimes less in some circuits, but in the Ninth Circuit it's a year and a half sometimes. You write your brief without even thinking about oral argument. Think about the fact that at oral argument you're only going to have a few minutes to talk about your case. That means you're going to have to be able to get your essence of your case out in one sentence, two sentences, 1 minute, 2 minutes potentially, given questions. If you're thinking about how you distill your case in that fashion for oral argument, you will write your brief in that fashion and have the court holdings and distilled arguments for you. When you get to oral argument in this appeal, it's not the time for a speech. It's not jury emotion time and argument. It's really a time to answer questions and answer them directly without being evasive at all. That's oral argument. Again, the next slide shows what's the disposition you want. And this ties back to our discussion earlier, but you must, at oral argument, also, as in your written advocacy, be very, very clear about what it is you want to happen on remand. The next slide is amicus briefs, and you need to think about potentially, as you're going on appeal and you're mounting your appeal, using an amicus party to help you. Amicus briefs are, quite literally as translated, friend of the court briefs. They trace an ancient lineage back to ancient Rome even, in the advocacy in the law courts in Rome. Today, it's a very strategic tool that can be very, very useful for you on your appeal, and it can be useful in different ways. By bringing in an amicus party, a third party that has an interest in the outcome, you do two things. You tell the Court of Appeals that this issue has significant broad import beyond just the two parties here and beyond whatever the court is thinking about, maybe the permutations and ripples. You've now got an identified party saying, we are greatly concerned about the outcome here. This can help you in your appeal in a couple of ways, and this is one important cardinal principle of appellate advocacy and being in the appellate world is defining your success. Here's an example. An appeal, employment appeal we once dealt with where it was an adverse ruling on the questions were whether stock options that were given vested or they didn't vest, and this is in a high-tech startup company. Obviously, it's an issue that has grand appeal and import to many, many companies in the tech space as they're handing out options. The case as litigated, of course, was just plaintiff-defendant. We got amicus support from many, many large corporations saying that the trial court's holding below was potentially damaging to the nature of how companies could incent, attract, retain good talent with options, and they wouldn't be able to continue to do it if the nature of how options vested were as the trial court held. Now, that can be successful in the sense that maybe you win your case, but it can also be successful in another sense. As a repeat player, you may cause the court to have enough alarm about the nature of the decision below that maybe it doesn't publish the opinion. So that maybe even if you have to lose because the nature of that contract was written in a certain way that it was unavoidable to get out of the outcome, maybe you can avoid a published opinion and you can signal to the court to be careful about publishing, or if it publishes, how broad the holding is, and avoid, if your client's a repeat player, these issues popping up again. That's an example of defining success in your appeal such that you can win even when you know you may have to lose at some point because the odds are against you, because you can avoid suffering comeback cases with adverse published authority. Another component to appellate advocacy is knowing that there are mediation programs. And in the Ninth Circuit and in the Federal Circuit Court of Appeals and in other circuits, there is a mediation program that lets you have a chance at fighting for settlement before you have to go on your appeal before the panel. Of course, the odds are long against you as an appellant, and it's useful sometimes to have an appellate mediator, someone who has litigated these issues and cases a lot, but litigated them on appeal a lot, so that the person is highly knowledgeable about, regardless of the merits you may believe your appeal may have, how the court in general is going to look at your issues, the standard of review, the amount of deference, that trial court that you're appealing from, those issues. That can be incredibly beneficial to you to get some really genuinely useful early insight as you get in mediations about your case and its likely outcome on appeal, and you're getting it from a player within the court, the internal court mediators, and sometimes they're highly respected lawyers who have litigated in that area for decades, who are now trying to help settle cases. These are scenarios that I think are highly useful to take advantage of, and you can sometimes get fantastic results. Example being, in one of my appeals we took up, we had a pro bono immigration case. We were looking to prevail, but the odds were very, very long against us at prevailing. Through the mediation program, we were able to bring enough pressure to bear, given the facts and circumstances of the case and the fact that we had got some public press attention on the case and some organizations now were writing about it. We were able to get to a point of finding a resolution that could give our client the relief our client ultimately needed, i.e. not being deported, without having to go the distance and face the high risk of losing. And of course, you have to give something up in terms of that. But it was a mediated resolution that was impossible to achieve as between us and the government lawyers, just simply on the state of the briefing. And if we had not had the mediation program, we couldn't have found that unique alternative escape hatch strategy. And so the mediators in the appellate programs often bring to bear a great amount of creativity in helping find resolutions and impart their wisdom and knowledge about what the courts may do in these cases and put pressure on both sides. So that's a useful example. Finally, if you loved your appeal, it was a great experience, you want to do more of them, different courts have pro bono appellate programs that give you the opportunity to take and brief appeals for pro se clients who have their appeals pending in the circuits, and the court will guarantee you an oral argument. You get a guaranteed brief writing experience also, and you get a chance to hone your appellate skills and work on all of these different tips and strategies that we've talked about throughout this program. These programs are fantastic opportunities at brief writing, your guaranteed oral argument by the programs, and you ultimately help the court. So at the end of it, you have been able to put in your toolbox more and more appeals so that for your private paying clients, when you get to work on those appeals, you are even better at it than you would be otherwise. Thank you very much for this program. I'm always welcome to take any questions by email, by phone. It's at onellp.com. And if you're still interested, the compendium program to this is on oral arguments in the Court of Appeal. Stay tuned. Thank you.